Proceedings are resumed. I recognize the Honourable Minister responsible for Financial Services with 1 hour and 15 minutes remaining.
Madam Speaker, thank you very much. Madam Speaker, when we took the break, I was referring to the Law Reform Commission report called a review of the law regulating legal practitioners in the Cayman Islands from May 2007. Madam Speaker, I think what I last referred to was the Commission taking into account the manner in which the United Kingdom regulates its overseas solicitors under the Solicitors Overseas Practice Rules 1990. And referring to the Commission's aim, which was to ensure that those practicing overseas will be regulated to the same standard as those practicing locally, with the necessary modifications to deal with this difference in circumstances. Madam Speaker, I went on to say the Commission therefore recommends the following minimum conditions for an acceptable system of licensing of non-resident attorneys. And they have set this out in bullet point form again, Madam Speaker, which I plan to go through. The first bullet point, Madam Speaker, says there must be a substantial nexus with the jurisdiction, and for this purpose, the definition of a recognized law firm shall apply to firms where the majority of partners or persons holding equity interests in the firm are Caymanian or persons ordinarily resident in the islands who practice primarily in the islands. Alternatively, at least half of the attorneys employed by the firm must be ordinarily resident or practice primarily in the islands. So, Madam Speaker, this concept that they talk about, this substantial nexus, this is the concept that's represented in this bill that has been published, that we have been commenting on. And that is reflected in the definition of qualified firm and the concept of a qualified firm that is set out in the bill, Madam Speaker. Madam Speaker, the alternative which they've set out is that at least half the attorneys employed by the firm must be ordinarily resident or practice primarily in the islands. Madam Speaker, that too, in principle, is reflected in this bill in the form of the Clause 68 ratio, which effectively tries to maintain a one-to-one ratio so that the substance of a firm and its versus its overseas offices or affiliates are roughly the same in the Cayman Islands versus the totality of its presence overseas. So if a firm in Cayman has 100 lawyers, they could conceivably have 10 offices overseas with 10 lawyers practicing Cayman law. And in terms of the reference to 100 lawyers, Madam Speaker, that was designed to also include to have article clerks counted as an incentive to hire and train more people. But the point, Madam Speaker, is that this concept is reflected in this first bullet point. And while they're talking about a nexus or an alternative being half of the attorneys resident are working in the Cayman Islands, we've combined both. So we've taken both concepts there to build around this nexus point, to build this connection to Cayman and to maintain the economic substance in Cayman. So the bill reflects both of those concepts. The next bullet point, Madam Speaker, is a partner of the firm will be required to report on any significant unresolved complaint or disciplinary action against the non-resident attorney outside of the Cayman Islands that comes to his knowledge. A failure to report will render a partner liable to discipline for professional misconduct. The bill, Madam Speaker, contains provisions which deals with partners being responsible to check and make certain declarations to the council. There's the third bullet point, Madam Speaker, is the non-resident attorney will be required, like all other attorneys, to file an annual certificate of good standing, if available, or an affidavit certifying he has not been the subject of disciplinary sanction by any disciplinary body outside the Cayman Islands that would be considered professional misconduct in the Cayman Islands before a practicing certificate can be issued. And the giving of false information will be an offense and grounds for a finding of professional misconduct. Again, Madam Speaker, this concept is reflected in the bill in principle around the requirements and the documentation that is required to be filed, in particular the affidavit that needs to be sworn when one is applying for admission as an attorney at law in the Cayman Islands. And certainly if there's any misrepresentation contained in that documentation, in particular the affidavit, one could be subject to disciplinary proceedings, or it could be considered professional misconduct, which ultimately could lead to even striking off if it's serious enough. The next point, Madam Speaker, is that the Complaints Committee may, if it deems necessary, carry out on-site visits to the jurisdiction in which the non-resident is practicing to interview complainants and witnesses, etc. Madam Speaker, I won't read the rest of that because I can say that those provisions are not specifically covered in the bill, but there are provisions which allow for the council to be able to make rules around issues like this, and it is certainly entirely possible for the council, having been empowered to make those sort of rules, to create that type of regime for those type of inspections and reviews to be carried out. Madam Speaker, there is the last bullet point on page 6 refers to the non-resident attorney, like the resident attorney, will be subject to rules of conduct set out in Schedule 5. Sorry, this was a reference to Schedule 5 to the bill which they had promulgated and attached to the report. Such rules would include provisions similar to those set out in the Solicitors Overseas Practice Rules, etc. That means, Madam Speaker, they would be subject to discipline. Again, Madam Speaker, the concept behind the bill that we have been debating is that all attorneys that are practicing Cayman Islands law, wherever they are in the world, would be subject to a requirement to have a Cayman Islands practicing certificate and subject to the disciplinary process. Madam Speaker, on page 7 of the report, there's a reference to an exam requirement. I won't bother to read these through in detail. They're a bit longer. The second bullet point deals with a probationary attorney, and that, Madam Speaker, seeks to address a situation where once the law is commenced, there is a business continuity process where persons who may be practicing Cayman Islands law would be able to continue doing something during that period of time, perhaps not the full practice of Cayman Islands law, so that they are given the time and the businesses are given the time to have them come to the Cayman Islands to be admitted. and filed the relevant documentation prior to that. So, Madam Speaker, all of these things, Madam Speaker, reflect, and I would say the rest of the bullet points on that page 7 of the report contains concepts which are similar in principle to what is contained in this bill, Madam Speaker. Madam Speaker, I think it's useful to indicate who the members of the Law Reform Commission were in 2007 at the time this report was prepared. Madam Speaker, the report shows the chairman as Mr. Langston Sibley's, the members as Mr. Ian Paget Brown, Mrs. Eileen Nervick, Mrs. Cheryl Richards, Mr. Andrew Jones, and the director was Miss Cheryl Ann Neblett. Now, Madam Speaker, we know that all of the individuals, chairman and members, are now Queen's Counsel in the Cayman Islands. So certainly the membership of that council was a fairly significant membership who, Madam Speaker, I can say, I suppose with the exception of Mr. Jones, who was a previous partner in one of the big law firms, the vast majority of them are not people that anybody could point to and suggest some sort of potential conflict. And as a judge, subsequently a judge, Mr. Jones is certainly someone who understands the issues of conflict. I make that point, Madam Speaker, simply to say that these are folks, these are people who are serving the country on the Law Reform Commission, trying to ensure that the issues in relation to the regulation of the practice of law are dealt with appropriately, and they're taking their job very seriously and making the necessary investigations. And for effectively the report that they have provided on the variety of points that have been through and demonstrated their alignment with the concepts and principles which are set out in the bill, Madam Speaker, I think it's very clear that you could almost say that the members of the Law Reform Commission were the originators of the concepts that are set out in the bill, at least insofar as putting it in a report 10 years before the current bill is actually being debated in this House, this Honorable House, Madam Speaker. So, Madam Speaker, I think where we're at with that is that this perspective, particularly after the view that, or the information that the drafting of the bill was not a cost to government and was paid for by industry representatives, Madam Speaker. I think this really clarifies the picture that whatever you may want to think in respect of that, and normally, Madam Speaker, you don't look a gift horse in the mouth. Certainly we thought that with the bill being aligned with the report to that extent, there should have been no risk that there was a view that somehow the bill was being crafted in a way which benefited the agencies or key stakeholders, Madam Speaker. I think that's very clear. Madam Speaker, I also want to touch very briefly on the information or the opinion and the very significant and valuable contribution made by the Honourable Attorney General on Tuesday evening when he added his contribution on the bill. I think he was very clear, Madam Speaker, for the first time in probably the history of discussion of this issue in the Cayman Islands, of his opinion that this question of whether law firms were committing some sort of offense under the existing law in doing what was necessary to promote the interests of the jurisdiction and respond to competitive pressures by having offices overseas was not a breach of that law, of the current law at all, but it reflected what we have been saying, the Bar Association has been saying for many years now, is that it's a gap in the law, it's a lacuna, and it is not in the interest of the jurisdiction, it's not in the interest of Caymanians and Caymanian practitioners to have that continue. So that, Madam Speaker, was certainly one of the driving impetus items that I listed. I think it was 3 of them that I listed when I presented the bill. So I think he also, the Honourable Attorney General, in his contribution certainly also spoke, Madam Speaker, to the whole question about whether there could be some sort of conspiracy. And he was very clear in his opinion that certainly that couldn't be the case either. So Madam Speaker, I hope that that issue has been clarified by that perspective, and that that opinion offered by the Honourable Attorney General, and this issue will be put to bed as an issue for discussion, or by us passing this bill and relegating the issue to an issue of the past, Madam Speaker. Madam Speaker, the Law Reform Commission report didn't obviously deal with what I indicated earlier, which is this difficult and vexing issue of addressing this discrimination issue that we have heard about in more detail recently, and we've heard, or certainly had indications of for many years now. Madam Speaker, the committee stage that amendments that we were proposing go a lot further than even what the bill contains at this point to ensure the further protection and promotion of the interests of Caymanian practitioners. And I'll spend a few minutes just outlining those, Madam Speaker. But I also wanted to address this issue of grandfathering, Madam Speaker, that was described in some of the contributions on the bill. Madam Speaker, the concept of grandfathering is one which involves typically the implementation of new standards or qualifications, and people or practitioners who might be engaged in that area and somehow are allowed to grandfather or to transition into a legitimate licensed role to continue what they've been doing without actually complying with the stated qualifications and provisions. And Madam Speaker, that's absolutely not the case in relation to this bill. The concept of grandfathering, Madam Speaker, is found absolutely nowhere in this bill, and it's an unfortunate misrepresentation of what it actually says. Madam Speaker, I touched on the Law Reform Commission's report and their recommendations in terms of being able to transition from, as a business continuity process, the transition from being unlicensed, uncertificated into a regulated and licensed practitioner. And that is all this bill does, Madam Speaker, it deals with a transition process which is controlled by the Council, Madam Speaker. So, Madam Speaker, what is the underlying factor at this point in relation to this issue? It is that the standards, the qualification requirements that are in the bill will apply across the board, Madam Speaker, irrespective of whether you are within the Cayman Islands practicing Cayman Islands law or outside the Cayman Islands. The standards, the qualifications, they're going to be the same. And very importantly, Madam Speaker, anyone who seeks admission to practice Cayman Islands law, if you're going to do it in the Cayman Islands, you're going to come to the Cayman Islands and you're going to stand in front of the judge. The judge will assess your qualifications. He will be able to look you in the eye and decide whether you're a fit and proper person and you have met the qualifications and requirements and admit you. If he decides otherwise, he won't admit you. Hopefully, it's not that embarrassing a situation where he's standing there and he does that. It would be an indication on the papers alone that those conditions haven't been met. But, Madam Speaker, the same requirement will apply on the basis of the terms of this bill to those who are overseas. They have to come to the Cayman Islands. They have to, all of them, whether you're going to be in Cayman or overseas, you have to comply with this concept of a 4-month period of supervision, plus pass an exam set by the Legal Advisory Council in the Cayman Islands to ensure, Madam Speaker, to better ensure that applicants have a solid understanding of relevant Cayman Islands legal principles at the time they're admitted to practice. So, Madam Speaker, there is no question, there is no grandfathering, there is absolutely no exemptions in terms of someone who is going to be practicing Cayman Islands law from the private sector perspective. There was also a question raised in relation to the post-qualification experience, Madam Speaker, and I would simply say that the transition provision for initially 3 years PQE to 4 years PQE, as set out in I think it's clause 34, that, Madam Speaker, was simply a transition provision. It was to allow any scenarios where negotiations were ongoing with individuals on the basis of the existing policy requirement of 3 years PQE before the 4-year was implemented. Madam Speaker, we have proposed as a part of the committee stage amendments a change to simply require 4 years from the start. Madam Speaker, I mentioned earlier that the local bar, the Caymanian Bar Association, and the Cayman Islands Law Society were very clear in their representations to the government in terms of the support and acceptance by their membership. I certainly asked them very specifically to give me confirmation in writing that that was the case, and that was provided, Madam Speaker. So it is very clear that the government felt that the key stakeholders in terms of industry representatives were reflecting to us that the terms of the bill and its concepts and mechanisms were supported by those key stakeholders. Obviously, Madam Speaker, it was equally clear that it wasn't supported by everybody, but certainly what was represented was that there was sufficient support that they could confirm to us that their associations had the necessary acceptance. Madam Speaker, there was a comment made about immigration requirements or getting around immigration requirements in terms of the proposed one-to-one ratio in clause 68, which I have mentioned earlier. That, Madam Speaker, as I said, that concept reflects a concept which was suggested as an alternative in the Law Reform Commission report of 2007, which concept was reflected in the bill. So surely, Madam Speaker, it wouldn't be the intention of those members of the Law Reform Commission to suggest that that sort of mechanism was designed to get around immigration requirements at all. And Madam Speaker, that doesn't really reflect the motives or motivations, or the drivers of business decisions for law firms. And yes, while the practice of law and those in it, that is a profession, an honorable profession, these days it is a business as well, Madam Speaker. And you even sometimes have managers of those businesses who are not attorneys themselves. So they make business decisions on the basis of business realities and business drivers with a view to ensuring that they have a business that is on solid ground, it generates income and net revenue for the business, and it has continuity, and it has substance and the ability to work through any perceived threats and take advantage of opportunities. So, Madam Speaker, those are not decisions that are taken lightly. Madam Speaker, there's also the provision which we have included in committee stage amendments, which relates to an important issue for us, Madam Speaker, which came about because of the consultation process that the bill went through subsequent to publication. And, Madam Speaker, some of those issues relate to concerns about ensuring the sustainability and the development of the local bar and balancing those interests, Madam Speaker, appropriately against the need to ensure that sophisticated clients and users of this jurisdiction, Madam Speaker, who, let's face it, oftentimes have very high value transactions that they are seeking to get some resolution of a dispute in relation to, that those people have access to who they think are the best people to help them resolve these significant issues for them. But it is our concern, Madam Speaker, to seek to ensure that there is an appropriate balance and that we try to seek a situation where there's sustainability and development of the local bar. And, Madam Speaker, that resulted in significant consultation with members of the judiciary and others to try to ensure that when an application is made for limited admission or to deal with specific matters for particular clients, that the judges have the necessary tools, Madam Speaker, available to them to balance those interests appropriately, so that, you know, if they think in the circumstances they're not satisfied that the local bar couldn't handle a matter, there is a construct, there are tools available to them on which to base a decision around that. Equally, if they're satisfied on the circumstances of the application and the representations made, Madam Speaker, that these issues could be resolved or appropriately resolved by giving admission to the specialist applicants, senior counsel or otherwise, that are seeking to be admitted. So, Madam Speaker, those are concerns that the government had in relation to that area, and it's something that we were concerned about dealing with very specifically. I'm just covering a number of points, Madam Speaker, that I don't want to really go into broad detail on the bill in terms of responding to every single point that was made. Madam Speaker, one moment, please. Just wanted to add, Madam Speaker, on the issue, on the discussion about overseas offices and lawyers practicing Cayman Islands overseas. One of the other drivers, Madam Speaker, is that over the last 35 years...
You have 45 minutes remaining.
Thank you, Madam Speaker. I appreciate that. What we have had is a shift from a scenario where 80% of the work was sourced from North American clients, North American-based clients, who are obviously within either on or within a couple of hours of our time zone, to a scenario, Madam Speaker, where it's actually, in some cases, less than 50%. On average, I guess you could say it's probably 50-50. And what that reflects, Madam Speaker, is the level of growth of business in terms of the sources of business in other parts of the world, particularly in the Asian markets. So that is just another underlying factor, Madam Speaker, as to why there's been more of a driver for overseas offices, simply because a lot of the source of business is just not in this time zone any longer, Madam Speaker. So, Madam Speaker, I hope with those remarks that there's clarity around the way the bill was drafted, why it has the terms it has, why it is essential to address the needs of the industry to have those practicing Cayman Islands law overseas properly regulated. Madam Speaker, that gets on very quickly to the issues of discrimination that we have heard about. I've talked about it to some extent. Madam Speaker, these are very vexing and frustrating concerns and issues, and in the past we have not had people step forward to any extent, and certainly not very willing, as we have all heard, to step forward and identify themselves. That has certainly changed, Madam Speaker. I remember in our discussions in the past, even at our caucus discussions over the last 2 years, comments about a group of Caymanian lawyers who were complaining about different things. But, Madam Speaker, they never came, never identified themselves, didn't make any clear representations to government. Perhaps they made some representations to certain people in the government at the time, but they didn't come and present their concerns and their issues to the government or even myself, Madam Speaker. So it is difficult to see whether there are issues that we need to address in respect to that without that sort of clarity. But we know one thing, Madam Speaker, there isn't a magic wand to address these issues. There isn't necessarily a silver bullet, because we're talking about behaviors, we're talking about culture in some cases. And Madam Speaker, let's be very clear. It's not a pervasive thing, certainly from my perspective, across all firms that are engaged in the practice of law in the Cayman Islands. Not to a significant level or consistent level. You may have some in some and more in others. But, Madam Speaker, whatever it is, we have to be concerned about it. And we have to ensure, and it's not right that there isn't clarity around how you progress in a law firm, how you get to partnership. That needs to be a well-understood process, Madam Speaker. And I think for some firms, I know for some there is clarity, there's an understanding. I have heard for others that I don't know specifically about that is less so, that it is effectively almost as clear as mud Madam Speaker. So those things, those types of things should not be allowed. There should be clarity around that, Madam Speaker. And we have included provisions, Madam Speaker, in the committee stage amendments, which seeks very specifically to address those types of issues. Madam Speaker, just very quickly run through the important aspects of the committee stage changes that we were proposing. Madam Speaker, in terms of the council, while originally there was two members of the council who were going to be appointed by representatives from small firms being less than 5 members, there is a proposed change so that, and that included, I should say, Madam Speaker, sole practitioners. There's been a proposed change to have sole practitioners on the council. And Madam Speaker, there are a number of committee stage amendments which relate to the council. There's a proposal that it's an all-Cayman or all-Caymanian council. There is the Section 36 provision dealing with limited admission to ensure that there's a balance between the interests of the client and the interests of local Caymanian practitioners at the bar. Madam Speaker, importantly, there's another provision which we sought to do, which was to ensure that sole practitioners got a very real benefit in the form of a reduction in their cost of the practicing certificate, and that was down to $650 from the current level, Madam Speaker, of $2,000. Madam Speaker, we also, just skipping to some very important aspects, we also included commitments which were previously discussed by the 5th elected member from Georgetown and some of the firms, I think, over the last year and a half, 2 years. Originally, those commitments were agreed to be the substance of regulations, but they have been elevated, Madam Speaker, to the actual bill in the form of an addition as a Schedule 3. And those things, those commitments, Madam Speaker, deal with access of Caymanians to the profession, the support and availability to get scholarships, training and progression, and it's backed up very much, Madam Speaker, by significant penalties if there is a failure to adhere to those commitments, Madam Speaker. Madam Speaker, I know it's often said in here that this is the house of politics, and we've had our share of that, Madam Speaker. But, Madam Speaker, I have to say that while we may engage in politics in here, the people of this country out there don't care about the politics. They care about what we can all do, working together to address solutions for their issues and their concerns. So they expect us to work together. And Madam Speaker, I didn't come here to be engaged in politics. I've always tried to avoid that and try to do what I have had to do in order to achieve the best for this country and the people, Madam Speaker. So, Madam Speaker, I am happy at this point to be able to say that we have, after trying a few times, we have all sat down, members from both sides of this honorable House, Madam Speaker, and spent I think the better part of about 8 hours or thereabout, working through concerns and perspectives and committee stage amendments that have been proposed, Madam Speaker. And I think, Madam Speaker, we have reached an agreement as to how we will go forward with the committee stage amendments. Madam Speaker, it means that some of these committee stage amendments are going to have to be drafted fairly quickly. Others will be accepted, some from both sides. And Madam Speaker, none of us are going to get everything, perhaps, that we wanted on either side. But I have outlined, Madam Speaker, why it is so critical to have a bill like this done. And I think I'm happy to say, Madam Speaker, that the members on the other side, the independent members, the official opposition members, participated in the discussions, perhaps not completely in terms of one person who had to, or who left a bit early, but there was a definite desire, Madam Speaker, to work together to achieve what's best for the country and to get a bill like this done. So, Madam Speaker, with your permission, I'd like to just go through what was agreed in terms of high-level principles, if that is okay.
Once you keep it general and don't go through committee stage by committee stage.
Correct, Madam Speaker. And thank you very much for your guidance. So, Madam Speaker, I think what I can say is the sort of first broad principle, Madam Speaker, is that the operation of the bill and the commitments bolted together will create an environment where over the next decade and a half, Caymanians will have the opportunity to come into the industry, to be trained, those who are in the industry to be further trained and developed, to ensure that they are very strong and capable associates, people who are capable of being partners and equity partners in these firms, Madam Speaker, assuming they're prepared to do the work, honestly, because it's not an easy path. It is not at all. And I can tell you that, certainly from my perspective, there are things that I perhaps regret having to spend so much time doing work as opposed to more important things. But that's just the way it is. Sometimes there are compromises you have to make. So, Madam Speaker, having that environment means that over the next 15 years, we want to see a majority of Caymanians being engaged as owners and controllers of Cayman Islands law firms. That is a very significant step, Madam Speaker. And it is one that we don't take lightly. It is one that has been driven by, obviously, the concerns that have been expressed. With people finally coming forward and putting their names forward and saying, yes, I have concerns and I have issues. But it isn't a light step, Madam Speaker. And it is something that we need to, as I said earlier, we can't subject ourselves to the mistakes of others in the past without learning from them. And I think this is a proposal which we seek to have a very positive effect on the opportunities and the interests of our Caymanian people, our Caymanian hardworking practitioners. But we have to constantly keep it under review to make sure that it is having the positive effects that we want, Madam Speaker. And that is where we're at as a group here today. We feel that this is a necessary approach, Madam Speaker. But it does behoove us to continue to ensure that it will have the impact that we want without having any undue negative ramifications. So, Madam Speaker, in addition to that sort of broad concept, we'll have to have what's typically referred to as a cure period of perhaps 2 years, and we will need to have a scenario where the Council of the Cayman Islands Legal Practitioners Association will have to have the ability to grant exemptions if it is evident that firms are, despite their best efforts, not quite making and fulfilling these obligations of a majority of Caymanian ownership. That's a similar concept, Madam Speaker, to what exists under the Local Companies Control Law at this point, but there's a big difference, Madam Speaker, in that the Council will be in a much better position with professional knowledge and understanding as to how to make these types of decisions in the best interests of all concerned, including the viability of law firms, Madam Speaker, and the interests of Caymanians who are partners and who seek to be partners. Madam Speaker, broadly, there's a second point in relation to the Council, the composition of the Council. Again, as I outlined briefly when I touched on our committee stage amendments, there's a proposal that those be all Caymanians. The way we seek to do that, Madam Speaker, is to have 2 nominations for each of the fee bands that exist in the current fee band schedule that relates to operating licenses, and have those, which is basically by the numbers of lawyers in the law firms. So have each of those bands nominate 2 people to Cabinet, and Cabinet ultimately make the decision between that, one from each of those bands. So they decide which of the 2 nominations they want to appoint to the Council, Madam Speaker. And I think that combines the democratic process of the firms making their nominations and Cabinet ultimately taking at least one of those, Madam Speaker. Madam Speaker, there's also a provision, or there's also discussion of, and this may not be in committee stage amendments, but the fees around the membership fees for the Cayman Islands Legal Practitioners Association will be increased in certain cases to allow for an element of those fees to fund continuing professional education training, Madam Speaker. And the thinking is that is done through the Truman Bodden Law School, because obviously that's a very significant institution in the Cayman Islands, and it is appropriate that it be involved and provide the venue for that sort of training, and the funding to deal with the necessary supplies around that, Madam Speaker, can come from these extra fees that are levied in terms of the SILPA membership fees. Madam Speaker, there's an agreement that the current 4-year PQE provision, as I mentioned earlier, in the committee stage amendments will stand. Again, there's an acceptance of the Schedule 3 commitments that are set out in the committee stage amendments to be added to the bill, which I think add a lot to it. Madam Speaker, there is also an agreement that there be a reference to the whistleblower legislation, which is included, at least by reference, in this bill at committee stage, so that it is clear, Madam Speaker, that any of those who have been involved in stepping forward and identifying themselves as people who have concerns about the circumstances in which they have been treated are not in any way affected by that in terms of any subsequent career moves, Madam Speaker. That's a very important thing for us. It cannot be allowed to happen where people are effectively blackballed or punished in some way, Madam Speaker. So we want to have a reference to that, even though perhaps the whistleblower law as it is would apply very specifically in this sort of instance. Madam Speaker, those are broadly the agreements that have been reached in respect of how we move forward with committee stage amendments. We've agreed some other, let's say, more minor ones that have merit, and we will have an agreed form of committee stage amendments which reflect these broad principles, Madam Speaker. I think, Madam Speaker, what we have seen over the last 2 weeks reflects a need for us to take very seriously some of the concerns that have been expressed, not just in relation to this profession or industry or business, in terms of the broader financial services industry, but industry and businesses generally, Madam Speaker, because there have always been concerns expressed, particularly in the last 5 to 10 years, that we have scenarios where jobs are advertised overseas, and that is well before they're advertised locally. Madam Speaker, we must have a situation where our people in the Cayman Islands are aware of these opportunities, at least contemporaneously or at the same time as anyone else. So we need to put some regulation around those issues to address those, Madam Speaker. Madam Speaker, I would certainly like to again thank all members of this Honourable House for the time that we have spent in deliberating this bill, considering the options to move forward and get to a point where we can get a bill in place, Madam Speaker, which serves the interests of the country and which serves the interests of the industry, the profession, and serves the interests of our people in the Cayman Islands, Madam Speaker. Madam Speaker, as I said earlier, it has been a difficult process. It has been a difficult journey dealing with this bill. And yes, I have had situations where I have been personally attacked. Others have been, But I think, Madam Speaker, this has come from all quarters. I'm not talking about within this House, Madam Speaker. To be fair, this is an issue that has been discussed in all corners, and we need to move forward and meet the needs of the Cayman Islands. Madam Speaker, I'm not, as I've said before, I recognize that this is the House of politics. So I try not to take these things personally, but I'm concerned with making sure that we have a bill that works for everybody, works for the Cayman Islands, protects our financial services industry and furthers our interests, furthers the interests of our people, and ensures that the legal profession can continue to be that integral, consistent, strong underpinning of all of the financial services industry, Madam Speaker, so that it helps to maintain and builds upon the jobs, the opportunities, the level of business that comes into this country and the revenue which this country derives from it, that is so important, Madam Speaker, in assisting our people in this country, giving the government the ability to provide the level of services that we do to our people. So Madam Speaker, again, I'd certainly like to thank those members on the other side of the House, the independent members, the 5th elected member from Georgetown, 4th elected member from Bodden Town, the member from Northside, the member from East End, the 3rd elected member from Bodden Town, the 3rd elected member from West Bay, the 4th elected member from West Bay, the 1st elected member from Bodden Town, although I don't think he went through the burden of the meeting last night, but certainly, Madam Speaker, the leader of the opposition was there for part of the meeting as well. So they've all played an important role in the discussions with us on this side of the House, Madam Speaker. And we're all very grateful that we're at a point where we have an agreement that we can move forward and deliver something which we feel is in the best interest of this country and the best interest of the industry, the best interest of the Cayman Islands and its people, Madam Speaker. So thank you very much.
The question is that a bill shortly entitled the Legal Practitioners Bill 2016 be given a second reading. All those in favour, please say aye.
Aye.
Against, no. The ayes have it, I believe.
Madam Speaker, given the historic nature of this bill, may I ask for a division?
Madam Clerk, please call a division.
Honourable Alden McLaughlin.
Aye.
Honourable Moses Kirkconnell.
Aye.
Honourable Kurt Tibbetts. Honourable Osborne Bodden.
Aye.
Honourable Wayne Panton.
Aye.
Honourable Marco Archer.
Aye.
Honourable Tara Rivers.
Aye.
Mr. Roy McTaggart.
Aye.
Mr. Joseph Hugh.
Aye.
Honourable McKeeva Bush.
Aye, till I see the third reading.
Mr. Barney Bush.
Aye.
Captain Eugene Ebanks.
Aye.
Mr. Alva Saku.
Aye.
Mr. Winston Connolly.
Aye.
Mr. Ezra Miller.
Aye.
Mr. Arden McLean.
Aye, conditional upon that committee.
Honourable Anthony Eden.
Aye.
The result of the division are as follows: 17 ayes. Accordingly, the motion is carried. The bill is carried.
The Supplementary Appropriation July 2013 to June 2014 Bill 2016. The Supplementary Appropriation July 2014 to June 2015 Bill 2016. The Supplementary Appropriation July 2015 to June 2016 Bill 2016.
The bills have been duly moved. The bills have been duly acknowledged. I recognize the Honorable Minister for Finance to move the bills.
Thank you, Madam Speaker. Madam Speaker, I beg to move the second reading of a bill of bills entitled the Supplementary Appropriation July 2013 to June 2014 Bill 2016. The Supplementary Appropriation the Supplementary Appropriation July 2014 to June 2015, Bill 2016, and the Supplementary Appropriation July 2015 to June 2016, Bill 2016. Thank you, Madam Speaker.
The bills have been duly moved. Does the mover wish to speak to these three bills?
Thank you, Madam Speaker. I do. Madam Speaker, this bill arises due to a requirement in the Public Management and Finance Law, otherwise known as the PMFL. Madam Speaker, honorable members are aware that circumstances will arise during the course of a financial year that necessitates changes to the appropriation law passed by the Legislative Assembly for any particular financial year. Oftentimes, Madam Speaker, the circumstances require prompt action, and the prompt action means that government does not have the luxury of seeking prior approval of the Legislative Assembly and Finance Committee before expenditure needs to be incurred. Madam Speaker, such scenario or occasion was envisaged when the PMFL was drafted, and the specific section 11 of the law, was formulated as a solution to circumstances that require very prompt action. Madam Speaker, the PMFL allows Cabinet, within limits, to incur expenditures that are not already approved by the by the Legislative Assembly, and are not incurred in annual appropriation laws. Madam Speaker, the limits imposed by Section 11, subsection 5 of the PMFL are that the expenditure should be no more than 5% of budgeted executive revenues for a particular financial year. Madam Speaker, the original budgeted executive revenue for the 2013-14 financial year was $612.1 million Cayman Islands dollars. The limit established pursuant to Section 11.5 of the PMFL for Cabinet-approved expenditure. And Madam Speaker, that translates to 30.6 million Cayman Islands dollars being the limit established by Section 11.5 of the law. Madam Speaker, whenever the Cabinet is asked to approve supplementary expenditures, ministries, portfolios, and offices are advised to, as far as possible, put forward expenditure reductions to mitigate or to counterbalance any increase in expenditures that the Cabinet is being asked to approve. The aim, Madam Speaker, is wherever possible to arrive at a net zero request. However, this is not always achieved, and sometimes net positive supplementary expenditure requests will arise. In terms of operating expenditures for the 2013-14 financial year, the net of increases and decreases to supplementary expenditures approved by Cabinet was a very modest $34,519. There are also changes to equity investments and executive assets. Equity investments is a term used to denote investments by central government in its ministries, portfolios, and offices, and its statutory authorities and government-owned companies, or otherwise known as SAGCs. The amounts so invested by central government are typically used to acquire fixed assets, those being long-term assets, Madam Speaker, and those assets are owned by the individual ministry, portfolio, office, or SAGC. Executive assets is a term used to denote the creation or acquisition of fixed assets, such as roads, shelters, and buildings that are not considered as owned by an individual ministry, portfolio, office, or SAGC, but rather are owned by the government as a whole. Madam Speaker, with respect to equity investments and executive assets, the net increase approved by Cabinet was a rather small $38,850. And during the 2013-14 financial year, the appropriation with respect to personnel loans was reduced by $85,000. Therefore, the supplementary request in the 2013-14 appropriation bill is significantly less than the $30.6 million that the PMFL allows for that financial year. It demonstrates, Madam Speaker, that the Cabinet was prudent in its supplementary expenditure approvals. Madam Speaker, the bill before the House is very simple. It consists of three main parts. Clause 1 gives the name of the proposed law. Clause 2 speaks to the appropriation authority of the Cabinet. And 3, the schedule to the bill, which shows the individual items of appropriation changes that the Legislative Assembly is being asked to approve. Madam Speaker, I respectfully ask all honourable members to support the bill for the 2013-14 financial year ending June 30th, 2014. Madam Speaker, with respect to the 2014-15 financial year, Madam Speaker, as with the 2013-14 financial year, this bill arises due to a requirement in the Public Management and Finance Law. Madam Speaker, this being the 2014-15 financial year that I'm on to now. The previous one being the 2013-14. The PMFL allows Cabinet to incur expenditure of no more than 5% of budgeted executive revenues for the 2014-15 financial year. Madam Speaker, as the original budgeted executive revenue for the 2014-15 financial year was $624.9 million, the limit established for Cabinet approved expenditure was $31.2 million according to law. In terms of operating expenditure for the 2014-15 financial year, the net of increases and decreases to supplementary expenditure approved by Cabinet was an increase of $10.2 million, Madam Speaker, broken down as follows. The three main items that dominated this $10.2 million were, number one, approximately $1.5 million was requested with respect to services to refugees. Madam Speaker, we would know that we have a regular flow of refugees from our neighboring island nation. Number two, 1.7 million was approved as a supplementary expenditure for preparedness and response to the Ebola virus disease. And number three, $5.4 million was approved to cope with the tertiary care at various local and overseas institutions for health care of indigents, seamen, and veterans that are referred overseas. Madam Speaker, that one is otherwise known as Output NGS 55. These three items account for 8.6 million of the total 10.2 million relating to operating expenditures. With respect to equity investments and executive assets, the net increase approved by Cabinet was a modest increase of $1.2 million. During the 2014-15 financial year, the loans made category within the appropriation law was reduced by a very small amount, Madam Speaker, of $12,000. Therefore, the supplementary requests in the 2014-15 appropriation bill are significantly less than the $31.2 million allowed by law within the financial year. And it shows once again that the Cabinet was prudent in its supplementary expenditure approvals. Again, I respectfully ask that honourable members will support the bill for the 2014-15 financial year supplementary appropriations. And finally, Madam Speaker, with respect to the supplementary appropriations for July 2015 to June 2016 bill 2016, again, Madam Speaker, it is required by this public management and finance law, that being section 11.5. Again, the PMFL allows Cabinet to incur expenditure of no more than 5% of budgeted executive revenue for the 2015-16 financial year. Madam Speaker, as the original budgeted executive revenue for the 15-16 financial year was $628.2 million, the limit established by law for Cabinet approved expenditure was $31.4 million. In terms of operating expenditure for the 2015-16 financial year, the net of increases and decreases to supplementary expenditures approved by Cabinet was an increase of $13.9 million. This overall amount of $13.9 million is dominated by three items. Number one, approximately $2.9 million was requested with respect to services for irregular migrants, that being the Cuban refugees, Madam Speaker. Number two, $1.4 million was approved as a supplementary expenditure for mosquito control services in the fight against the Zika virus, Madam Speaker, and we recall that we had approximately 20 cases at last count. And number three, $5.9 million was approved to cope with the tertiary care at various local and overseas institutions for health care of indigents, seamen, and veterans that are referred overseas. Again, that is NGS 55. These three items account for $10.2 million of the total $13.9 million relating to operational expenditures. With respect to equity investment and executive assets, the net increase approved by Cabinet was a very modest $2.1 million. Therefore, the supplementary requests in the 2015-16 appropriation bill are significantly less than the $31.4 million that the PMFL allows for the financial year. And it shows, again, Madam Speaker, that the Cabinet was prudent in its supplementary expenditure approvals. I respectfully ask all honourable members to support the bill. Thank you, Madam Speaker.
Does any other member wish to speak? Does any other member wish to speak? Final call. Does any other member wish to speak? If not, I'll recognize the Honourable Minister for Finance should he wish to reply.
Thank you, Madam Speaker. Just to thank all honourable members for their tacit support of the appropriations just mentioned. Thank you.
The question is that bills shortly entitled the Supplementary Appropriation July 2013 to June 2014, Bill 2016, the Supplementary Appropriation July 2014 to June 2015, Bill 2016, and the Supplementary Appropriation July to June 2016, Bill 2016, be given a second reading. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Accordingly, the Supplementary Appropriation July 2013 to June 2014, July 2014 to June 2015, July 2015 to June 2016 bills have been given a second reading.
The Utility Registration and Competition Amendment Bill 2017.
I recognize the Honourable Minister responsible for infrastructure.
Thank you, Madam Speaker. Madam Speaker, I was pondering here, and I am going to be dealing with these 5 or 6 bills, hopefully in short order here. But just before I do that, I would certainly not wish to attract your ire or for you to think for 1 minute that I disrespect the person or the post. So therefore, I will humbly ask if you would allow me exactly 90 seconds to speak to an issue which is not concerning this bill. And it will not take long, and it will not attract any debate.
The question is that the Honourable Minister would wish to have 120
Yes, no more.
seconds to deal with the matter not presented on the bill. All those in favour, please say aye.
Aye.
Against, no. The ayes have it. Please proceed accordingly, Minister.
Thank you, Madam Speaker. Madam Speaker, I simply wish to say, because I suddenly realized that while I was in the middle of the fray with the long and arduous task of arriving at the completion of the second reading of the Legal Practitioners Bill, I hadn't spoken at length, and I don't intend to make that attempt. What I want to say, Madam Speaker, is that I thank God that my faith has been restored in the membership of this Honorable Legislative Assembly. Because I have to be totally honest with you and say that there were times during this whole affair when I wanted to do what the Honorable Deputy Speaker and I make joke about sometimes, I won't go home. Having said that, I want to extend my personal thanks to all of those members who at the end of the day accepted that this was bigger than any one of us individually, and it was all about what was in the best interest of the people and the country, and we rose to the occasion and accomplished just that. And Madam Speaker, I am confident that we will see it through to the end where a new law can be put into effect. And I trust that enough lessons have been learned within and without these hallowed halls to ensure that stability prevails and our Caymanian people can hold their heads high and be proud. Thank you.
Minister, I wish also to note and to thank the members of the Honourable House that nobody stood up on a point of order and that he was not resurrected in debate, but because of the role that which he played, I allowed it to go on, not knowing the content of it. But I wish to say, Honourable Minister, the first elected member from Bordentown, the leader of the opposition, that although Cayman does not yet have the Nobel Peace Prize, if there were such a thing, that as far as the chair could observe, it should be awarded to you three in this particular things. That is not saying that other members did not have a particular role, but sitting from a periphery, I think that the valiant effort that was made by all members, the chair certainly appreciates and would ask members to so use it as a forward precedent. Honourable Minister for Infrastructure.
Madam Chair, Madam Speaker, thank you, thank you, thank you. And I know that when you say it, you call three bodies. When I say it, I can exclude myself and still call three bodies because that would be inclusive of your good self. Madam Speaker, I beg to move the second reading of the utility registration. No, or the paper is not correct. The utility regulation and competition bill, amendment bill 2017.
The bill has been duly moved. Does the mover wish to speak thereto?
Yes, Madam Speaker. Madam Speaker, members will recall that at our last meeting, we passed the utility regulation and competition law. And Madam Speaker, there were several companion pieces of amending legislation to the ICTA law, the ERA law, and I did say I corrected it. I said regulation. Yeah, Madam Speaker, as I was saying, I did say that there were a few other companion pieces of legislation to complete the puzzle, fit the picture out, and I am ever so grateful to have the opportunity now to hopefully get these passed. The first one is that I'm doing the second reading to know, Madam Speaker, is a simple amendment. And the amendment is fairly clear in the memorandum of objects and reasons of the bill. And it reads, this bill seeks to amend the Utility Regulation and Competition Law 2016 to change the respective designations of two members of the Board of Directors of the Utility Regulation and Competition Office. Following changes is what we wish to make, or are what we wish to make, I should say. A, the designation Executive Director of Information will be changed to Executive Director of Information and Communications Technology, and the designation Executive Director of Energy would be changed to Executive Director of Energy and Utilities. And Madam Speaker, those very minor changes to the law are simply to apply correct names to the two titles that are referred to in the bill. I trust that members will see it fit to give their support.
Does any other member wish to speak? Does any other member wish to speak? Final call. Does any other member wish to speak? Honorable Minister for Infrastructure, do you wish to exercise your right of reply?
No, Madam Speaker, except to say a very special thank you to members, and I hope that I can say this for the next 5 bills, that we'll be able to get them passed. Some of them are a little bit longer than others, and we do have a few committee stage amendments, but I do appreciate the tacit support of members.
The question is that a bill shortly entitled the Utility Regulation and Competition Amendment Bill 2017 be given a second reading. All those in favor, please say aye. Aye. Against, no. The ayes have it. The Utility Regulation and Competition Amendment Bill 2017 has been given a second reading.
The Water Sector Regulation Bill 2017.
The Honourable Minister responsible for infrastructure.
Madam Speaker, I wish to move the second reading of a bill for a law to provide for the regulation of the water sector by the Utility Regulation and Competition Office and for incidental and connected purposes.
The bill has been duly moved. Does the Honourable Mover wish to speak thereto?
Yes, Madam Speaker, just craving your indulgence. Thank you, Madam Speaker. Madam Speaker, if we examine our order paper, we will see that the next 4 bills are all related to the water sector, and that is combined, they are to facilitate the change of regulation of the water sector from the Water Authority of the Cayman Islands. That is the economic regulation from the Water Authority of the Cayman Islands to ERCO, or off-reg, as the office has been dubbed. The water sector bills which I am now bringing, Madam Speaker, are part of a slate of bills to complete the merger of the utilities regulatory functions under the Utility Regulatory and Competition Office, and thus finalize its position as the entity with regulatory oversight for the island's utilities sectors. This, Madam Speaker, is one more step in the government's agenda to drive the regulatory reform agenda. In the passage of the ERCO, ICTA, ERA, and the Dangerous Substance Amendment bills, which were done at the last meeting of the House, we emphasize that this new regulatory framework consolidates an environment that fosters sustainable growth and innovation. The reform also affords us the opportunity to build regulatory capacity which will address the changing needs of consumers, promote competition, and also assist in addressing the gap between development and commercial opportunities. Madam Speaker, the water sector bills seek to finally remove any perception whatsoever that the government's owned water producer and supplier, the Water Authority of the Cayman Islands, is in any way conflicted in regulating other operators within the sector. The removal of its function in legislation as an economic regulator is a key strategy that will allow the authority to focus on its core business of water production and supply, and also its water resource regulatory functions. And so I am happy, Madam Speaker, to bring these bills, albeit one by one, to the floor of this Honourable House. Madam Speaker, the first one, which I've just moved the second reading for, the Water Sector Regulation Bill 2017, makes provision for the regulation of the water sector by the Utility Regulation and Competition Office, which was established under Section 4 of the Utility Regulation and Competition Law 2016. The bill provides for the economic regulation of service providers of water and wastewater services. It also provides for promoting the development and deployment of new technologies in water supply and wastewater services, where such technologies will, in the long term, bring economic benefit for the economy of the islands and financial advantages to consumers. I want to just point out to this Honourable House what I consider to be some of the significant components of the bill. For instance, Madam Speaker, it is important to note in the definitions, the term service provider includes both the Water Authority and concessionaires. This is the mechanism by which the Water Authority is brought under the regulatory supervision of the office. The intent being that OFREG will issue an administrative determination that will set out the framework that the authority will be regulated. In Part 2 of the bill, Clause 3 confers a number of powers on ERCO, including the power to monitor and regulate the tariffs, the rate structures, and the terms and conditions for water and wastewater services charged to customers. The office is required to carry out its powers in a manner that is consistent with the general regulatory principles which are set out in the schedule. Part 3 of the bill contains clauses 4 to 13 and deals with water supply services and wastewater services to third parties. And under this part, Madam Speaker, the following provisions apply. A, unlicensed persons are prohibited from providing water supply or wastewater services to third parties. It is mandatory for a person who has entered into a concession agreement with the government to apply to the office for a license. It is also mandatory for a person who has entered into a concession agreement with the government and has been granted a concession to supply potable water or wastewater services to a defined geographic area to apply for a service provider license. For example, the water company supplying a certain geographical area in West Bay will fall under this category and will have to make their application. A service provider license is valid for the duration specified in the relevant concession agreement. And Madam Speaker, let me take this opportunity to say that while there have been ongoing battles to get that specific matter sorted out and getting that license regularized, ERCO will now be with proper framework legislation that they will then be able to deal with this matter and bring it to conclusion. A licensee, Madam Speaker, is also prohibited from assigning a license without the office's consent. So in other words, if some bright soul bought out Cayman Water Company, they would not be able to pass their existing license once they do have a license to supply potable water to that certain geographical area. They would not be able to pass that on without the office's consent. The renewal of a service provider license is subject to the terms set out in the relevant concession agreement. A service provider license may be modified with the mutual consent of the relevant licensee and the office, and a service provider is required to pay regulatory fees to the office. The office, Madam Speaker, is empowered to take possession of water or wastewater infrastructure in certain cases. For example, where there is a fundamental breach of a license, the procedures will be set out in the regulation to be developed later on, and a register of concession agreements and licenses is to be kept. So, Madam Speaker, just so that we can understand clearly, where it says that the office is empowered to take possession of water or wastewater infrastructure in certain cases, this, where there would be a fundamental breach of the license, and as I said, the procedures will be set out in regulations which are being prepared as we speak. Madam Speaker, this would only happen in extreme circumstances, but the reason why you want this in this legislation is so that you do not have the franchise area, for instance, being totally without water or wastewater services at any one point in time because of a breach by way of the licensee, at which point in time one may have, meaning the office may have to step in and take over the operations for continuity of service, even if it's on a temporary basis. Madam Speaker, Part 4 is comprised of Clause 14 and deals with the interconnection of water supply or wastewater systems and provides for the operators to interconnect their systems when mutually agreed. Part 5 deals with consumer protection, and it also provides for the office to prescribe standards of performance in connection with the provision of water supply and sewage services to customers. In Clause 16, this addresses the issue of data protection and requires service providers to maintain strict confidentiality in respect of consumer information. Part 6 of the bill contains clauses 17 through 22 inclusive, which are the miscellaneous provisions. Clause 17 creates an offense of malicious damage to property in respect of damage to apparatus relating to the collection and treatment of wastewater. 18 makes provision for a compensation order by a court in any case where a person is convicted of an offense under the legislation.
We have reached the hour of interruption. I recognize the Honorable Minister of Planning or Deputy Premier, either one, to move the motion for the suspension of 10-2.
Thank you, Madam Speaker. Madam Speaker, I move the suspension of Standing Order 10-2 in order the House work past the hour of interruption.
The question is, that Standing Order 10-2 be suspended to allow the House to work beyond the hour of interruption. All those in favor, please say aye. Aye. Against, no. The ayes have it. Standing Order 10-2 suspended. Honorable Minister for Infrastructure, please continue.
Thank you. Madam Speaker, Clause 19 makes a provision with respect to consultation by the Central Planning Authority with the Water Authority or a concessionaire if they are in receipt of plans for the construction, reconstruction, or extension of a building in their respective service areas. In addition, service providers are required to deposit with the office maps showing public water supply and public sewage lines owned or operated by the service providers. Finally, Madam Speaker, the schedule sets out a framework of general regulatory principles to guide the office and emphasizes the important principles of sustainability, stability, transparency, and predictability in the discharge of its functions. So, Madam Speaker, this bill to provide for the regulation of the water sector by ERCO is certainly one which we are seeking approval for in the Legislative Assembly. And Madam Speaker, and let me just say this for everybody's clear understanding, the bills as I bring them forward, members will note that there have been committee stage amendments proposed to these bills, and the simple truth of the matter was because of the timelines in getting the bills here within the 21-day timeline, there was some consultation which took place subsequent to that, and we certainly did not want to not pay attention to those points brought out by stakeholders, and hence the reason for the committee stage amendments. So I trust that members can see the wisdom in bringing this bill and that they will be able to support it through to it becoming a law. Thank you.
Recognized Honorable Leader of the Opposition.
Thank you, Madam Speaker. I need it because I don't have no technocrats behind me. I don't think they will help at this point. They could have been, I suspect, if we had that kind of system where opposition were informed, but we come here to listen, sounds like. Madam Speaker, I paid attention to this, and the truth is, I pay attention to all bills, but normally leave that to people like the member from East End, who deals with utilities a lot. But because I have been chairman of the Water Authority before, and minister responsible, and because our public water system in West Bay, my constituency, is done by a private company, I made some observations and, of course, did have some concerns indicated to me by private sector. Madam Speaker, the definition of administrative determination perhaps should be looked at to refer to the definition of that term in the Utility Regulation and Competition Law 2016 in the same manner as the Water Authority Amendment Bill does, since the definition as it stands contains the term sectoral participant, which is not defined in this bill, but which is defined in the Utility Regulation and Competition Law 2016. I see the gentleman smiling. It must be that he had notice of some of these things before. You got it. Well, as I say, concerns are raised to me, and so the minister can explain. That would be the right thing. I have to wonder, though, if the authority or a concessionaire should be changed in the definition of RACM because a distinction is made between the two in terms of administrative determinations. In that respect, Madam Speaker, it is different from the definition of public water supply system. In Clause 5, Madam Speaker, while it makes sense, I think, for any permits issued to supply defined developments by the authority should be converted into operator licenses issued by the office, there is, and I should say, why is there a need for the authority to continue to be involved in issuing permits for that purpose going forward? Again, Madam Speaker, the principal point, from my thinking anyway, of the water laws is to remove the authority from regulating water supply and wastewater licenses. It also appears that they have now removed the need to have a concession for an operator license, and so to that extent, Cabinet might be removed from the picture, and I would ask that they tell me whether that's a fact or not. The proposed amendments in Clause 10, Madam Speaker, are, I think, somewhat problematic for several reasons. A, the current provisions in respect of compulsory divestiture probably or broadly reflect the provisions of Section 27 of the ERA law. And we understood that one objective of that exercise was, so far as possible, to standardize the mode of regulation of service providers in the various sectors. Subject regulation, Section Clause 10, I'm speaking to about 27 of the ARA law. Madam Speaker, subject regulations by the office, and B, the proposed amendment seeks to remove the basis on which the licensee's undertaking is valued from the law and put it in regulations which do not seem yet to exist, and I would need to know that as well. Perhaps they might have it in draft form, but we certainly don't know about it. So we would not have an idea of the proposed content. In C, the proposed amendment moves from divestiture of the assets of the license to the land or works owned or operated by the service provider licensee. The respective terms appear to be very different in scope, and I am puzzled by the intended purpose of this change. D, the power to compulsorily divest the land or works of the licensee would no longer merely be on the basis that the license has expired, but also when the license is revoked, while not allowing for any appeal against revocation, and more alarmingly, I think, when needed for a public purpose. The nature of those concessions, Madam Speaker, is that they serve a public purpose. So the result of that provision would or might give the government the power to do whatever at will with a privately owned business which is operating on the basis of a concession granted by the government without that business having been in breach of any term of its license or provision of any law and independent of any state of emergency. Madam Speaker, we don't have many laws to go by in this instance because this is the first. Sorry? Huh? You know you didn't. I know. Yeah, we will listen to you when you come next now. No. But as I said, we're just fresh as a country going into laws like this. And this is, we talked about the Public Utility Commission for years. When I was a minister in the 90s, yes? No, that's what we have talked about it for years. When I was minister in the 90s of the Water Authority and the Port Authority, and also on the Airport Authority, which is really not a utility, but I also served on Cayman on the CUC board for a number of years. And Madam Speaker, we don't want to say it's draconian, but it goes much further, for instance, than the land acquisition law, where land may be compulsorily acquired, for example, to build roads. I believe it is unprecedented in our local legislation. As I said, we don't have much to go by, but we do have some regulatory laws that we can go by, and we have regulatory laws to be applied by the office. And I would think that private sector is going to find that totally unacceptable. What I just said. And propose, the minister needs to direct his questions, Madam Speaker. His technocrat is listening good. And you just make me give my view forward. I made myself clear because I don't hide anything, Madam Speaker. It's not something that I usually speak on, although I serve for a long time on the board and as the minister. But I do have some concerns. We only have one water company that serves us in West Bay. Only one, and I have to be concerned about that. So I want to make sure that myself, as a member of the House, and the minister, and we are on all fours in trying to get what is best when we go to the Utilities Commission to regulate it. We want the best. And in the proposed clause 12.4, the words whomsoever it deems appropriate, wonder if that is what you want, and whether that could be replaced by the competent operator, which picks up on the term used in clause 12.1. In the proposed clause 12.6, the appointed operator will only be liable for damage occasioned to the assets of the licensee if it arises from their gross negligence or willful instruction. Madam Speaker, this is a novel formula for an exclusion or limitation or liability clause from what I know about some of those areas in law when you're dealing with such things as those kind of...
Leader of the Opposition, you said 12.4?
12.6, the appointed operator will only be liable for damage occasioned to the assets. The bill? That's not the same bill? That's the same bill we're talking about.
Madam Speaker, if the member will allow me, just to be helpful.
Honourable Minister for Infrastructure.
I think we've I think members have some proposed committee stage amendments for this bill. And I think some of what the contribution is being made is speaking to those committee stage amendments. That is why they're not found in the bill itself.
Because there are amendments to come. For those that are today paying close attention to me and listening to me today, it's a proposed clauses. Yes. That I'm speaking to at this point. Huh? Well, we're not supposed to. We're not supposed to get to them before we get to them. But I was so caught up in it that I thought I would put my views on it. And if the speaker allows, and don't stop me on the basis of the orders, because I'm speaking before we get to it.
That's a very good effort, Leader of the Opposition, but you know that only so much I can allow, I have allowed, so please continue to disallow. You can do it.
Madam Speaker, the truth is I will wait. I'll have more scope in the committee stage to ask some questions. But, Madam Speaker, what I am concerned with most of all, that whatever government is doing, we are not going to hamstring business to the point that, because we do need to regulate it, that we all know, but that is not going to raise costs at the bottom end. Meaning that Cayman Water Company is going to be regulated. I am hoping, and what I'm saying is that we don't get to the point where they're going to come back to say we have to raise costs because of what government has done. And so we can't do nothing about that. You know and I know that that is sung in good tune. Yes. And that's all I'm saying, because I can tell you, I pay enough water bills for people down there already, just like some of you all pay on this end. And we don't need to get to the point where it's going to go higher. And that is what I am hoping, that with the regulation will come a point where you're digging in deep enough to say, like we say to CUC, enough is enough. You can only get this much out of it now. Okay, that's at the end of the day, Madam Speaker. And Madam Speaker, I know that you had this ministry as well, and you know some of the problems that we have faced. So you are not unfamiliar with it. And so, Madam Speaker, if the House don't carry on too long, and I don't know if we get to these tonight, I will leave the balance of the, I wouldn't seek to you know, get it till tonight? No, tonight is Friday night, please don't. Please don't. So, Madam Speaker, I will leave my thoughts at that point and wait till when we get to the committee stage.
Does any other member wish to speak? Recognize a member from East End.
I know you don't need this.
Thank you, Madam Speaker. Madam Speaker, I guess I should declare my hand. I have concerns about all of these water bills. These bills that are related to water production. But let me, and Madam Speaker, I should say that I have similar concerns as the leader of the opposition on these committee stage amendments and the like. I also have concerns of the water company remaining a regulator I have serious concerns with that. Yeah. Madam Speaker, like the leader of the opposition said, we have talked about a utilities commission forever. Your good self, the leader of the opposition, the current minister, myself, my predecessor, we have talked about it forever. But what I'm seeing here, with all due respect, Madam Speaker, does not achieve what our dreams were, which was, and I can speak specifically to mine, which was that we would have a regulator that regulated everybody, a commission that regulated everybody. But when you intersperse some of the government operators as partial regulators, we have a problem. Well, Madam Speaker, for fear of breaching the protocols, the Water Authority still has certain controls on water and waste management. And allowing them to issue license and for such has to be concerned. It's not about the necessary abilities of people. It is about the conflicts that will arise between the office of the Utility Regulation and Competition Office. For instance, Madam Speaker, a simple one is the Utility, the Regulation and Utility and Competition Office, competition law, does not include in it the type of mechanism they are using for rates. It doesn't. Now it's represented in the Water Authority and it's represented in the Waste Sector Regulation Bill. And those are the ones that should be regulated by the Regulation and Competition Office. I don't know if there's anything wrong with the RCAM being put in here, but certainly it must be in the regulatory bodies bill in order that it's enforceable. And then when the office, and I refer to the office as the Regulation and Competition Office. When Madam Speaker, was all well and good when I did the ERA, because that was for a specific utility. And it would have been well to put it in the Water Authority law and this law if we did not now have an overarching office. Pardon me? Okay, all right, all right. The minister has indicated it's coming in the regs, but the competition law been in place long time? Orco or? Oh yeah? That's when cousin went on it? But madam, we should have had that in. Madam Speaker, if we're going to move forward with the rate structure calculator that I developed 2005 to 2009, we need to have put that in there. If that's going to be a standardized thing across the board, RCAM, if that's going to be our way forward to calculate rates for utilities, and Madam Speaker, RCAM is only the concept. The numbers can change whenever you so choose. But if that's the system we're going to use, then it needs to be in the law, with the regulation saying that those quantities may be moved depending on the type of utility. For instance, the CPI, we apply, I think, 40% of the US one, and then we remove certain things out of the CPI, in Consumer Price Index. That's one of the formulas we use, one of the numbers we use in the formula on our CAM. And if we're going to different utilities will require different aspects of the CPI being removed before it's applied to the calculation. So it needs to be put in law if that's the way forward. Because right now, you could very well have a situation where the office has no means of manipulating that, or if they try to manipulate it, they get objection there too. Madam Speaker, I know when I reach the Water Authority bill, I'll have much more to say, but I'm a little concerned about some of these provisions wherein the Water Authority continues to have part of their enforcement abilities. I'm very concerned about that, because there is going to be conflicts between the Water Authority and overarching arm. And I ask nobody, I am speaking from experience as a minister with constitutional responsibility. I had my difficulties with the utilities, especially when there were provisions in the law. For instance, can only give general direction and not on a particular matter that is being considered. In difficulties, I'm talking about not face-on difficulties, but resistance. And I can just imagine, and not all of the people were of that mindset, but I can just imagine people considered an office that is considered unequal, but really supposed to give direction. And we have to be careful we don't go one step forward and two steps backwards in this business. There needs to be a regulator that all others must listen to. This ain't no equal among men. This is not equal among men. This is one of many. And the decisions must be made there. There is no shared decision possibility. That is why, Madam Speaker, all our lives we have had difficulty in the fuel industry because there was no one person making decisions on what needed to happen. There is nothing easier, Madam Speaker, than utilities and the application of formulas. Liars can figure, but figures don't lie. Well, if you're an engineer, they don't lie. If you're an engineer, they don't lie. When they present themselves, you can depend on it. Accountants, now that might be a different thing. 2 + 2 can equal anything you want it to be. But when it comes to engineering, that has to be 4, or you're going to mash up whatever it is. There is no maybe or perhaps. And therein lies my great concern about this. One person, you don't need 2, 3 people to say that those are the numbers. You need the other person to tell you what the parameters are. But the same results will be achieved. Madam Speaker, I want the minister to think about what I just said. I'm not here criticizing. I'm trying to avoid what I see as a possible difficulty down the road. I see it. I feel it. Madam Speaker, it's... I see the amendments, and that's what I'm trying to walk around without getting the speaker to come down on me with a ton of bricks.
You saying you're not being transparent, member from Easton?
I don't know. I don't know. Well, I'm trying to through you, Madam Speaker, talk to my good friend, the minister, but I don't want to go directly into it. And it's about those amendments that I see coming there that is going to cause a little hiccup and that kind of thing.
Honorable Minister for Infrastructure and a point of elucidation.
Yes, ma'am. Madam Speaker, on a point of elucidation, just so the member will know, I am quite happy for, before we go to actual committee stage, I am quite happy to sit with a member or any other member who wishes to sit along with the technical staff so that we can hear what those concerns are to ensure, not trying to cut the debate, but just to be able, because the concern the member raised seems to span across more than one of the bills. So because of that is why I'm making the offer, which would be not in the chamber here and before we actually get to committee stage with them. I'm saying I'm happy to do that so we can get a clear understanding.
Honorable Minister for Infrastructure, I thought while you were in an offertory mode that you were going to do an adjournment, but I was anticipating. Honorable Member from Easton.
Madam Speaker, I can move the motion.
At least let me wind this one up.
Okay. Yeah, Madam Speaker, I am happy to sit with the minister. I hope. Let me put it on the record. The Premier said they got wind this one up and then we going home. Madam Speaker, it has been a long week. It has been very long. Even the Premier has bloodshot eyes from this week. So do I. You know, we all of us. So, Madam Speaker, I'm happy to sit with the minister and go over some of these things that we want, but I'm sitting with him going over that fuel one, because that fuel one has some difficult provisions that I can't. I guess we'll have to deal with that too, Madam Speaker.
Does any other member wish to speak? Does any other member wish to speak? Final call. Does any other member wish to speak? Not a call upon Honorable Minister for Infrastructure.
Thank you. Thank you. Madam Speaker, first of all, let me say that I'm quite happy, and as the Honourable Member from East End has intimated, we can, Monday morning, spend a few minutes to go over those concerns to make sure that we're on all fours. But there are a couple of points I want to make based on what the Honourable Leader of the Opposition has said and what the member for East End has said. Madam Speaker, the Leader of the Opposition spoke to the fact of not wanting that because of the utilities regulation and competition office becoming a reality, that the franchise holder in his district would not be raising the prices, the water rates. I want to say publicly that it is our intention to get to the point by way of ERCO to be able for those rates to be lowered not to be increased. And the points that were being raised regarding the committee stage amendments, Madam Speaker, not to make a cloud out of anything, but those points were sent to my technical staff a half hour ago. So we certainly did not have chance. They were sent from private sector. So we haven't had a chance to look at them. We've had more than one meeting with stakeholders on it. We're certainly willing to look at anything that's new again, although we thought we had gotten to the end of the road. But if not, that's okay. We're not going to. This is about getting it right. So we will look at them. And I just wanted the Honourable Leader of the Opposition to know that. The point about Arkham, Madam Speaker, if the member looks at the bill in the definition section, the water sector bill, in the definition section, he will see Arkham in bold letters down on the bottom of page 9. It says Arkham means the mechanism for determining and modifying prices for services rendered by the authority or a concessionaire to consumers as approved by the office and specified by the office in administrative determination issued by the office in respect of the authority or in a license issued by the office to a concessionaire. And just so that the member will know, and perhaps we can broaden the perspective and the discussion on that on Monday morning, each of the bills refers to Arkham. And the member is right. Arkham is a principle, not necessarily all of the formulae being the same. So we can talk about that, but I just wanted. I understand. So we can go through all of that. Madam Speaker, no, it's getting late. And perhaps if we got this one, second reading completed, I'm in the hands of all. I would have liked to do one more, but what I don't want to do, Madam Speaker, is to cause any consternation at this time on a Friday afternoon because things have gone so well. So, let me anticipate, Madam Speaker, that members would be quite willing to vote for this, although there are some committee stage amendments, and then on Monday morning we can have a discussion with the Honourable Member from East End and whoever else wishes to be part of that discussion. We can go through that to make sure we're on all fours when we come to the committee stage amendments. Thank you, Madam Speaker.
The question is the bill shortly entitled the Water Sector Regulations Bill 2017 be given a second reading. All those in favour, please say aye.
Aye.
Against, no. The ayes have it. The Water Sector Regulations Bill 2017 has been given a second reading.
Madam Speaker, unless someone else has something, I don't have a problem with them going through the water ones. I have difficulties with the fuel one. The water ones has some serious problem. The fuel one has some serious problems with it. In my debate to come.
Honourable members, in order to facilitate this request in the interest of time, the Honourable Deputy Premier and myself would wish to vacate the chamber at this time and ask my deputy to take the chair. As neither of us own private jets and we would seriously like to get home this weekend. Honourable Deputy Premier. Members, please stay in your seats. Thanks.